Guys, I'm Rakshana Begum. Today I'll discuss with you federal features of Indian Constitution. Let's start. Federalism is a system of government in which powers have been divided between the center and its constituent parts such as states or provinces. It is an institutional mechanism to accommodate two sets of politics, one at the center or national level and second at the regional or provincial level. It makes an important part of Indian polity syllabus of the IAS exam. This article will introduce you to federalism in India notes. Indian federal system, two types of federation. Number one, holding together federation. Number two, coming together federation. In a federation system, there are two sets of power that are autonomous in their own spheres. A federal system in that sovereignty is constitutionally split between two territorial levels so that each level can act independently of each other in some areas. There are two kinds of federations. Number one, holding together federation. Number two, coming together federation. Holding together federation and examples. In this type, powers are shared between various constituent parts to accommodate the diversity in the whole entity. Here, powers are generally tilted towards the central authority. Example: India, Spain, Belgium. Coming together federation and examples. In this type, independent states come together to form a larger unit. Here, states enjoy more autonomy as compared the holding together kind of federation. Example: USA, Australia, Switzerland. Features of the federal system of India. Number one, dual government polity. Number two, division of powers between various levels. Number three, rigidity of constitution. Number four, independence judiciary. Number five, dual citizenship. Number six, bicameralism. All federations might not have all the above features. Some of them may be incorporated depending on what type of federation it is. Federalism in India. India is a federal system but with more tilt towards a unitary system of government. It is sometimes considered a quasi-federal system as it has features of both a federal and a unitary system. Article 10 of the Indian Constitution states, India, that is Bharat, shall be a union of states. The word federation is not mentioned in the Constitution. Elements of federalism were introduced into modern India by the Government of India Act of 1919, which separated powers between the centre and the provincial legislature. Federal features of the Indian Union. Governments at two levels. Number one, government at two levels, center and states. Division of powers between the center and states. There are three lists given in the seventh schedule of the Constitution, which gives the subjects each level has jurisdiction in number 1 union list, number 2 state list, number 3 concurrent list. Supremacy of the Constitution. The basic structure of the Constitution is indestructible as laid out by the judiciary. The Constitution is the supreme law in India. Independent judiciary. The Constitution provides for an independent and integrated judiciary. The lower and district courts are at the bottom levels, the high courts are at the state levels, and at the topmost position is the Supreme Court of India. All courts subordinate to the Supreme Court. Unitary features of the Indian Union. There are 15 parts here. Let's see who is here. There are 15 parts here. Number 1, the flexibility of the Constitution. Number 2, more power vested with the center. Number 3, unequal representation of states in the Rajya Sabha. Number 4, the executive is a part of the legislature. Number 5, Lok Sabha is more powerful than Rajya Sabha. Number 6, emergency powers. Number 7, integrated judiciary. Number 8, single citizenship in India. Number 9, governors appointment. Number 10, new states formation. Number 11, all India services. Number 12, integrated elections machinery. Number 13, veto over states bills. Number 14, integrated audit machinery. Number 15, power to remove key officials. Number 1, the flexibility of the Constitution. The Constitution is a blend of flexibility and rigidity. Certain provisions of the Constitution can be easily amended in case the amendments seek to change aspects of federalism in India. The provision to bring about such amendments is not easy. Number 2, more power vested with the center. The Constitution guarantees more powers with the Union list. On the concurrent list subjects, the Parliament can make laws that can override the laws made by a state legislature. On some matters, the Parliament can also make laws regarding certain subjects in the state. Unequal representation of states in the Rajya Sabha. The representation of the states in the upper house is based on the state's populations. For example, Uttar Pradesh has 31 seats and Goa 1 in the Rajya Sabha. In an ideal federal system, all the states should have equal representations. Number 4, the executive is a part of the legislature. In India, the executive in both the center and the states is a part of the legislature. This goes against the principle of division of powers between the different organs of the government. Number 5, Lok Sabha is more powerful than Rajya Sabha. In our system, the Lok Sabha is more powerful than the upper house, and unequal powers to two houses is against the principle of federalism. Number 6. Emergency powers. The center is provided with emergency powers. When an emergency is imposed, the center has increased control over states. This undermines the autonomy of the states. Number 7. Integrated judiciary. The judiciary in India is integrated. There is no separate judiciary at the center and the state levels. Number 8. Single citizenship in India. In India, only single citizenship is available to citizens. They cannot be citizens of the state as well. This helps in increasing the feeling of nationality as it forges unity amidst regional and cultural differences. It also augments fundamental rights such as the freedom of movement and residence in any part of the nation. Number 9. Governor's appointment. The governor of a state acts as the center's representative in the state. The state government does not appoint the governor, the center does. Number 10. New states formation. The parliament has the power to alter the territory of a state by increasing or reducing the area of the state. It can also change the name of a state. Number 11. All India services. Though the all India services such as the IAS, IPS, etc. center interferes in the executive powers of the states, these services also offer uniformity in administration throughout the nation. Number 12. Integrated election machinery. The Election Commission of India is responsible for conducting free and fair elections at both the centre and the state levels in India. The members of the EC is appointed by the President. Number 13. Veto over states bills. The governor of a state can reserve certain kinds of bills for the president's consideration. The president enjoys absolute veto on these bills. He can even reject the bill at the second instance, that is, when the bill is sent after reconsideration by the state legislature. This provision is a departure from the principles of federalism. Number 14. Integrated audit machinery. The president of the country appoints the CAG who audits accounts of both the center and the states. Number 15. Power to remove key officials. The state government or state legislature
does not have the authority to remove certain key government officials even at the state level, like the election commissioner of a state, judges of the high courts, or the chairman of the state public service commission. Federalism is an important principle, and federation in India is especially relevant for the UPSC exam.
Please like, share, and subscribe on my YouTube channel. Thank you.